My name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about Contract of Indemnity. As per Section 124 of the Indian Contract Act, an agreement by which one party promises to save the other from loss caused by him by the conduct of the promisor himself or by the lead of someone else is classified as the Contract of Indemnity. The term indemnity means to make good the loss or to compensate for the losses. To protect the promisee from unanticipated losses, parties enter into the contract of indemnity. It is a promise to save a person without any harm from the consequences of an act. There are two parties involved in the contract of indemnity. The two parties are indemnifier, someone who protects against or compensates for the loss of the damage received, indemnity holder, the other party who is compensated against the loss suffered. For example, A contracts to indemnify B against the consequences of any proceedings which C may take against B in respect of a certain sum of 200 rupees. This is a contract of indemnity. In the case of Mangladharam versus Gandamal, the vendors promised to the vendee to be liable if the title to the land was disturbed was held to be one of indemnity. Insurance indemnity. All insurances except and personal accident insurance come in the scope of indemnity. It is an absolute promise to indemnify the insured. Upon the failure of performance, a suit can be filed immediately irrespective of the actual loss. If the liability is incurred by the indemnity holder and is absolute, he or she would be entitled to call upon the indemnifier to save him from that responsibility by taking care of it. An insurance policy that compensates a party for any accidental damages or losses up to a certain limit, usually the value of the loss itself, is known as indemnity insurance. Legislative and judicial enactment of contract of indemnity under English law. Basically, a contract of indemnity is a more extensive idea in English law when contrasted with Indian law. In light of the fact that in English law every one of the issues is viewed which are connected not just due to the demonstrations of some individual, yet additionally emerges from some occasion or mishap if there should arise an occurrence of fire or demonstration of God. Certain rules under the contract of indemnity under English law are: when the loss will be faced by the indemnity holder, if instructions of indemnifier is followed by the indemnity, if indemnity holder incurs cost during any suit proceedings and pays the amount by compromise. The rule of agreement of indemnity started in English law in the judgment of Adamson versus Jarvis, where Adamson was an offered party and Jarvis was a litigant. The offended party by calling was a salesperson to whom Jarvis, who was not the proprietor of the dairy steers, gave the cows and was sold at the deal. The veritable owner of the steers sued Adamson for change, and he was fruitful in it, and Adamson expected to pay the damages for something comparable. Thus, Adamson sued Jarvis to be compensated for the adversity that he caused to pay the harms to the proprietor. From the above case, it is examined that there was a guarantee to save the individual from misfortune, yet the guidelines hosted to be trailed by get-together of the gathering that is reimbursed to guarantee repayment. The law was further changed by the case of Dugdale vs. Loring. It showed that the guarantee may be conveyed and gathered. For the present circumstance, the KP company and respondent were insured for explicit trucks which were in the responsibility of the insulted party. The correspondence was held between the irritated party and defendant, in which the outraged party's uneasiness for inquisitiveness with regard to whether they pass on the trucks to be the respondent. The prosecutor, without outfitting a reaction and uncovered to him that sent all of the trucks back to him, the KPCO brought a case against the irritated party for the change, and the insulted party needs to pay the damages. Thus, the outraged party sued the respondent for indemnity. For the present circumstances, the court held that the irritated party is equipped to recover reimbursement, considering the way that there is no objective of the annoyed party to send the trucks without indemnity. Hence, for the present circumstances, there is a construed insure which is agreed by the respondent when he told that sent all of the trucks back to him. By then, it is normally expected that he agreed rights incurred by an indemnity holder. Section 125 of the Act describes the right of an indemnity holder. Any fee he was forced to pay in a matter or a suit to which the indemnifier's guarantee extends will be recoverable. C. Any cost that the indemnity holder may have to pay to a third party are also recoverable. However, the indemnity holder should have behaved prudently and in accordance with the indemnifier's instructions. Any amounts charged under the suit or compromise, as long as it was not against the indemnifier's orders, are also recoverable by the indemnity holder. Rights of an indemnifier. Despite the fact the Act mentions the indemnity privileges, the Indian Contract Act of 1872 excluded indemnifier rights. In Jaswant Singh versus the state, it was concluded that the reimbursed advantages are like those of a guarantee under Section 141, where the person who indemnifies gains the advantage of all protections held by the loan boss against the vital borrower, regardless of whether the foremost account holder was worried about them. Thank you.